contract and to make sure that the people have indemnified you and are going to hold you harmless and going to pay for any claims that get filed against the county that result from them doing something at the county fairgrounds, right? The next step is to make sure that they can really make good on that promise, that they have the financial capability of actually paying the claims that get filed against the county. And that's what I'm going to cover is that how to make sure that they've got the insurance, because that's what most people use in order to make good on that promise to indemnify you. You know, when I was talking about the day after the deaths at the Military County facility, one of the scariest phone calls I got later that day was the county attorney called me and said, I just talked to the mayor, and who is also the president of the Lions Club, and you know, we have this process that we always agreed over the years that, you know, they sign an agreement with the county to use the facility, and the lease requires that they have insurance in place, and they send us over their certificates of insurance, and everything just is all smooth, and we got the process down. This year they forgot to get the insurance purchased. That's not a good thing. So, you know, it's great to have the contracts and to have the procedures and everything, but if you don't take this step and make sure that the insurance is in place and it's the insurance that they need to have to protect you, but also themselves, none of it's worth anything. Because now people are losing their homes and their cars and their summer property and everything they own. So, our objectives today is really to answer the question of why is it that we need to collect these certificates of insurance to make sure that people have liability in workers' comp. And it's really because you're trying to protect the county by way of indemnification, and you need to also know why contractors, lessees, and renters need that insurance to protect the county, and then you use the certificate of insurance to verify that they're actually doing that. And, you know, it's kind of one of those, just how far do we have to go to get this done? Well, you know, are we going too far? I mean, we just want to have a little fun. If people show up with their cars or their horses at the fair, what's tough on it? But as we'll see, I mean, you've all got one example at least in your counties. I know because I've signed the check of something going wrong at the fair. And so we really need to be careful about it. And as Dale talked about, it's all about the indemnification, that somebody's coming and using your facility. Somebody's coming and participating in an event that they want to have at the county facility. If you get sued, if the taxpayers of your county get sued because of they're having fun on your property, who should pay? The taxpayers? Because they built the facilities with their tax money? Or the person who's using the facility for their event? It should be the person who's using that facility. So when you're contracting with another party, the party paying for the service, leasing the property, or renting the space, wants to be indemnified. And it's only fair that they are indemnified. Sometimes you'll want to protect the county, and other times they're going to want you to indemnify them. You're doing something for someone else. And you, as Dale said, you want to be fair. If they want to be indemnified when the county is holding themselves out as the expert, then you indemnify and defend them and give them a certificate of insurance. So it goes both ways. Dale talked about the indemnification clause to indemnify, defend, and hold harmless, because you know, he talked about hold harmless. You want to get them to pay. But there are some costs that, you know, are going to be reimbursable, like the county attorney's time and effort, that they're not going to pay him directly, but the county should be reimbursed for that time and effort that any of their staff puts in to defend that claim. Sometimes you don't want this other vendor's insurance company to hire your defense counsel. I mean, we have a really good selected team of defense counsel for counties that know how counties do business, know all the immunities that are available to you, know all the liability limitations that are provided to you by law. We want them defending you. So, and the other thing is, who wants on the front page of the newspaper, county settles claim for injury at the fairgrounds? Doesn't sound good. If they're going to be defending you directly, they're probably going to settle that claim as fast as they can, as fast and as cheap as they can. So you want the opportunity to have indemnification of you defending yourself to make sure that you are defending the actions of the counties. Because they aren't interested in whether or not you were negligent. An insurance company is going to be. They're interested in spending as little on that claim as possible. And our defense costs at USIP, defending the counties, is almost all of the money we spend out of the fund is defense costs. We rarely pay a liability claim. Very rarely are the counties found at fault. But 80% of those claims that we spend a lot of money defending, if we were an insurance company, we'd settle it for a fraction of the cost early on. But that isn't what you want. You want the county to be shown to have not done anything wrong. That's really important. And because of that, over the years, we don't see the big law firms that advertise late at night, here in the valley at least, don't sue counties anymore. Because they know we don't send them out a settlement check. They send us video, CDs with a video on why it is that we should just write a check for $1 million and say goodnight. And they call several weeks later, we haven't gotten an offer from you. Well, no, we're not extending an offer. We're going to trial. What? Yeah, the county did nothing wrong. We have immunities, we have defenses, we're going to trial. Attorneys, plaintiffs' attorneys hate going to trial. That's a lot of time and effort. They want to settle. But we don't do that. And a lot of them have learned that now. So we're dealing with a lot of outstate attorneys that don't do a lot of litigation. That helps us as well. So the indemnification, defense, and hold harmless, Dale went through this real quick. So they're going to pay the claims, they're going to pay for defense, they're not going to make claims back against you as a result, and it should include all claims arising out of the indemnitor's negligence, out of their negligence. Dale talked about you can include all claims arising out of the activity, except the claims that arise out of your sole negligence. That's the one place where I don't completely freak out about sole negligence language. But you should, anytime you see that sole negligence, bring it to the county attorney, because that's probably an indication that it's bad. Again, there's always an attorney out there waiting to sue you. They're in lines trying to find it, because, and especially when you're dealing with a lot of other small vendors, and a lot of the people that you have at the fair, some of the people that just have their, they have a little booth up and they're just giving out information. No big deal. Well, when they do something wrong and injure someone, and they don't have any insurance, the county's going to get sued. And the plaintiff's attorney is really going to go after the county because you're the deep pocket. You have unlimited resources, financial resources. You can tax. What they've find out really soon is you're also limited by law as to what someone can sue you for, which we'll talk about in a minute. So to indemnify or to be indemnified, and this is what I mentioned real quick before the lunch break, is a lot of people confuse this, and it's easy to get confused, apparently. Vendors that come to you are confused about it. Others should indemnify the county when they are providing a service to the county. When they are renting, leasing, or using property or space of the county, or they are asking permission to conduct activities that the county regulates. They should indemnify you under those conditions. All the time I receive contracts from department heads and counties where they're hiring a service provider. They're hiring a guy with a backhoe to do a little bit of digging. And he's got a contract that he's just given the department head. And it says the county will indemnify and defend the backhoe operator from any claims or suits that arise out of his activities. He's holding himself out as the expert. He should be indemnifying you, not the other way around. When you should indemnify others is only when you're providing the service under a contract to that other party. Then you would indemnify them. When you're renting or leasing their property or space, you would indemnify them. When you're conducting business or activities on another person's property, like the city, then you would indemnify them. Okay? So, we're going to go through this real quick. Game show, indemnity or indemnitor. So if you're indemnifying someone, you're the if you're being indemnified, you're the indemnity. If you're agreeing to indemnify someone else, you're the indemnitor. Okay? So a contractor doing remodel work on a county facility, should the county be the indemnity or the indemnitor? Indemnity. The contractor is going to indemnify you for any claims for what he does. Contractors usually are pretty easy. County's leasing space for temporary offices. You would the indemnity or the indemnitor? Indemnitor. In this situation, if you cause trouble in their building, you should pay for it. Not a problem. Firm providing consulting work for the county. Indemnity. They are holding themselves out as the expert. You are paying them. County wants to hold an event that will cross another person's property. Get this all the time with races, bicycle races, running races. You're going to go across the BLM land, Forest Service land. They always want to be indemnified. You are the indemnitor. You are going to agree that if your race causes problems that they get sued for, you'll indemnify. Business or organization wants to use county facility for a special event. This is you guys. Indemnity. So any performer that comes to you and says, oh, by the way, you need to indemnify me. No. You are indemnifying us. You're using our facility. Okay. City and county are co-managing a facility where the city runs the activities, but the county maintains the facility. This is the Dixie Center in St. George. The county owns the facility, they maintain it, but the city organizes all the events inside the Dixie Center under an interlocal agreement. So who indemnifies who? That's a trick question. That's the cross indemnification that Dale talked about. It's where each party agrees to indemnify each other for each other's negligent acts. You should use that when you are in this kind of a mutual aid type agreement. Again, when you're hiring a contractor who's supposedly a specialist in the area of service he's providing to you, there's no reason to do a mutual indemnification. He indemnifies you, and that's it. If, however, you're providing some service back, or you are overseeing some portion of the project, something like that, then that's the place where you consider doing cross-indemnification. Okay? Dale talked real quick about the limitation of liability and why would you ever do that? Why would you limit the liability of a contractor? Generally, you should not agree to limit the indemnitor's liability at all, unless it's another governmental subdivision. If it's the city or another county, you might as well agree to limit the liability to the statutory limitations, because the courts are going to do that anyway. But the problem with this and the argument that you hear all the time is, well, geez, I'm doing a $2,500 job for you, and I'm going to put my entire company at risk, all my assets at risk for this one little job. You wouldn't expect, you can't really expect me to do that, can you? It's like, well, yes, I can. That's why we're gonna ask that you have insurance to do that for you. But the other thing that I see occasionally is they make this argument when they're trying to argue that they're not really an independent contractor. Now, they said that they were an independent contractor and they didn't have any employees, so they were exempt from workers' comp law. But the other guy that showed up with them and got hurt, they're trying to claim as a county employee and should be paid workers' comp by the county. And they're trying to argue that they're not a contractor. Well, then they point to this. Well, look, they limited my liability under my contract to the amount of the contract. I couldn't lose. I stood to make money in every situation as a contractor. That's one of the dozen or so indicators of being an independent contractor or not, is whether or not you stand to win or lose. If a contractor is always going to make money, the courts don't consider them an independent contractor. They're getting paid as an employee. They have to be able to stand to lose. The agreement should clarify that liability is not limited by insurance requirements in the agreement or the indemnitor's insurance that they purchase. Because many of you, in your agreements, say you have to buy at least $1 million of general liability, $1 million of auto liability, and have workers' comp. Make sure that you also make sure that they understand that that's the minimum requirement that we're asking for. That's to protect you. If there's a $5 million claim filed against the county, and that's the judgment against the county, you're indemnifying us for $5 million. It doesn't matter what we put down as minimum requirements in the contract or what you bought. Your obligation is to indemnify us in full. That usually has them thinking, well, maybe I do need to buy higher limits on my liability insurance, because they still have that obligation. And again, because you are a governmental subdivision, just to be fair, when you're indemnifying another person, you should point out to them that, by the way, by state statute, our liability is limited. This is another quick story about why you don't let these people limit their liability to any amount. This is downtown St. Cloud, Minnesota, where I was born. This is right downtown. These are 3 different really popular restaurants. You can see they're right by the Radisson Convention Hotel, where the Association of Minnesota Counties used to hold their, or does still hold all of their conventions. So this is these are 3 locations that I used to frequent after hours after the convention. But early one morning in December of 1993, the small cable company hired a guy with a backhoe, a couple of guys with a backhoe, to dig out underneath the sidewalk to install some fiber optic cable right along the street. Trying to bring the internet to St. Cloud, Minnesota in 1993 is a big deal. So, this 2 guys with a rented backhoe figure, wouldn't it be the perfect situation where they'd say, this is a pretty small contract. Can't we limit our liability and not have to indemnify the cable company for whatever amount it could be? And how much insurance do you ask for a couple of guys like that? $1 million? Sounds like a lot, doesn't it? I mean, I used to tell people, ask for $5 million. Oh, they're screaming. They can't get $5 million. They can only get $1 million. Okay, if that's what you want to do. Well, just before lunch on this Wednesday, I believe it was, in December, people are starting to fill the restaurants for lunch. These 2 guys are digging out here with a backhoe. They start smelling gas. They think they hit a gas line. So they call the gas company. The gas company comes out. Yeah, there's gas. We don't know where it's coming from, but there's definitely gas. So they start evacuating the restaurants. Already you're talking about business income loss to these restaurants who are going to want to get paid by somebody, right? Well, before they get everybody evacuated and get the scene completely cleared and figure out where the leak is, something ignites the gas. That's the result. All 3 restaurants obliterated. The 2 guys, one of the guys found the backhoe, and one of the guys that worked for the gas company are dead. Lots of people injured. Looks pretty bad. You can see here is the Radisson building. That building had to be completely reviewed by an engineer to determine whether or not it was structurally sound any longer. The reason that I got real involved with this was I was working for the Minnesota County's insurance at the time. This is where the blast occurred. This is the county courthouse. This is the county administration building. They blew up all of these windows with all the employees inside there. All of these windows were all blown out. We had dozens of county employees, cuts and scrapes and things from the glass flowing into the buildings. These buildings, again, all of these buildings had to be reviewed to determine whether or not they were still structurally sound or not. You understand the ramp at the Radisson had some additional engineering done on the parking ramp because of the concussion of the blast. But you see why you wouldn't have let these guys get away with limiting their liability to the size of their contract, and why maybe even $1 million isn't enough. This was a lot more than $1 million loss. Okay. So the question is, how do you know that they're going to be able to pay, that they're going to be able to live up to this obligation to indemnify? Well, first of all, you look at what are their financial resources. If the person that's using your facility is Kennecott, and you're arguing over whether or not they can indemnify you or not, they can probably do that on a chump change over at Kennecott. But just about anybody else, you're going to want to make sure that they have a way to live up to that obligation of indemnifying. If it's a city or a school district or the state, again, they have the financial resources to indemnify. Don't get hung up on that. Everybody else is who we're talking about. Because most indemnitors are going to use insurance to do that. So you want to require that they have insurance. That's the standard in contracts, is that they have requirements for insurance. And again, as counties call me and say, well, how much insurance should we ask from this person? It really depends on the risk. If they're coming to the fair to show off the newest quilts that they made for the year, not very much. Okay? If they're selling food, more. If they're selling chainsaws that they're giving presentations on, or four-wheelers that they're letting people take rides on, even more. If they're the carnival, as much as you can possibly imagine. Right? So it all goes along with the risk, and those are considerations for you in your county to consider. You also have to make sure when you're making those insurance requirements that you are considering the risks that they need to cover. Because general liability policy only covers certain things. Has anybody ever read an insurance policy that doesn't have an exclusion? No. That's what they're built on nowadays. They provide coverage to you, and then they take it away with exclusions. That's the way it's done. So unless you know what the exclusions are, you don't know if the event that they're doing for you even is covered by the general liability policy. Required insurance should be maintained beyond the completion of the agreement, depending on the indemnitor's policy terms, and we'll talk about that when we look at the actual certificate. Because, of course, you want to be covered for whenever that claim is made, right? And depending on what type of policy they have, it might not be covered. That policy may not cover the loss when you get sued 2 years from now. So set the required limits carefully, and again, make sure that you clarify somewhere in that agreement that those are minimum limits that you're requiring, but they do not limit their liability. That by saying, yep, I got the $1 million you asked for, well, if we have a $2 million claim on seizing your property, to indemnify us. How much liability do we have? As a county, you are limited, and I've referred to this a couple times. The most that anyone can sue you in state court for is for $281,300 for damage to their property per occurrence. So, Paul was talking over lunch about the guy who had his sound system blown over by gusts of wind at this county fair a couple of years ago. If he had $300,000 worth of equipment, it doesn't matter how negligent the county was in damaging his equipment, he's getting $281,300. That's it. Can't ask for more than that. Okay? For any one injury to any one person, they can only sue for $703,000. So even though a jury says, yep, that person's damages are $1.5 million, the judge is required by state law to reduce that down to $703,000. And these numbers they're odd because they're increased every 2 years by the state risk manager according to the cost of living. Okay? And for any number of persons who get injured in one occurrence, the most the county can be sued for is $2,407,700. That's the limit. So when you only ask for $1 million of insurance from the vendor, and you can be sued for 2.4, that's not even before the amount that the vendor themselves has to pay. Was $1 million enough to ask for? And this is a good conversation to have with them. You realize that we can be sued up to $2.5 million. You can be sued up to an unlimited amount. Do you really want to only have $1 million of coverage? We're requiring it, but don't make it, say this is not a huge imposition on us. You want to protect yourself and your business. You should probably think about having higher limits if you're coming to the fair and doing some new event that you've never done before and you've only got $1 million limits. Okay? How much should we require? Again, just very basic. Again, you've got to really review this and consider this. But when counties call me, I tell them an absolute minimum. No one should be coming to you with a policy that's less than $1 million. That is so standard in the industry. Anybody that tells you they cannot get a general liability policy for $1 million has had such horrible experience or defrauded an insurance company to such an extent that they can't buy the insurance. That would be the reason. Any business should have no problem getting $1 million policy. Anybody that can't, you probably don't want to be doing business with anyway. An exhibitor that has sales, $1 million per occurrence with at least a $2 million annual aggregate. Now, we haven't talked about aggregates yet. An aggregate means once, this policy is going to be good for 12 months. We'll just say January 1st to January 1st. So they come to you in August with their certificate and say, yep, I got a $1 million policy. It's got a $1 million annual aggregate. $1 million policy. Great. But they had a big problem back in March that there's a huge lawsuit over. That $1 million is already gone. They're coming to your fair with no coverage at all. Because once you hit this aggregate number, that's it. The policy is done. They won't pay another cent over that $1 million or $2 million, whatever that aggregate is. No matter how many claims there are out there, you're just out of luck. So now you are, again, after that individual or that company seizing their property to indemnify the county for the loss. Okay, so those aggregates are real important. If it's an entertainer or performer, again, at least $1 million with a $2 million aggregate, at least. Depends on what they're performing. When St. George, when Washington County called me and said, we've got this guy that wants to take a school bus and jumping over a bunch of cars on fire and crash into a brick wall at the end. How cool is that? You okay? How much insurance do you ask that guy to have? Probably asking for $1 million is enough, because what underwriter is going to sell a policy for $1 million to do that, right? And again, Carnival, a minimum of $2 million per event, because they can do that. A lot of the people you work with will be buying insurance, not just a carte blanche annual policy. They'll have special events policies for special events. So those will be written on a per event basis. So look for that if they're a performer of any type, that their limits are provided on a per event, but then they might also have the aggregate.
Yeah, I was just gonna ask, so that kind of takes the aggregate out of it, then it's per.
It might not take the aggregate out of it. It might be $1 million per event with a $5 million annual aggregate. Those are things you need to look for.
So how do we know if their aggregate's being used up if they're not honest?
That's the
Do we
problem.
contact the insurance company on everything?
Well, you could contact the insurance company to see if there have been any claims filed as of yet. The other thing you can do is if it's a risk that you're concerned about, is to ask them to get a per event limit for your event. Or to get a special events policy specifically for your event.
Will the insurance company tell you? Can they tell you?
Maybe they can.
Well, it depends on what the case is. Well, if you're additional insured though on that policy, which you're asking to be,
But I'm asking to be, I'm not currently.
yeah.
So that's the problem I'm seeing is with the, privacy laws, if I'm not already additional insured, the insurance company is not going to tell me. So then what do we do?
Well, you can ask for a loss run from the policyholder.
But if they're filed on and not awarded yet, they won't.
They won't know.
Well, if they're filed though, the insurance company is going to have that loss reported on the loss run.
And will they
Even
let
though
me
it's not
know that?
awarded?
They won't know how much money they're going to end up paying on that claim, but at least you know they have other claims filed against that policy.
Will they tell you that?
Well, again, they may not. That's why this is not a science. That's the summary of all of this. There is no science. There's absolutely no way to know for sure. Unless you have them buy a policy for your event and you're getting certificates issued directly from the insurer, not an agent, not a broker, but the insurer, you don't know.
That's why, so that's what we need to do. All
Yeah.
the rest of this,
Yeah.
we don't even have to do. We just have to ask for exactly what you just said.
Yeah. That is the way to best protect the county. It's a real pain.
Yep.
So again, you look at which vendors do we do that with? The Carnival? Yes. The little ladies showing their quilts?
I don't know why.
They,
the insurance
they're probably
policy-
getting a certificate issued by the local agent who is your brother-in-law anyway.
Yeah.
But again, that's your county's decision of how well we want to be protected. Because if they can't indemnify you, if they can't pay the claim, if their insurance doesn't cover it, the county's on the hook for up
So
to
when you're
$2.4 million.
leasing your fairgrounds and there's a rodeo, a carnival, do we have to have all those certificates in place with the lease?
Well, the thing is, if it's a promoter that's putting on the whole show, you get the indemnification from the promoter that obligates that anyone that's there, that the promoter is required to indemnify you. You get him to have this per event limit for your event so that you know that the limit's not used up somewhere else and set that limit. And then he has to worry about whether or not all the other people that are coming to his event as the producer, he has to worry about whether or not they can indemnify him. So you can wrap it up like that by using the producers. You've got a problem if you put on the derby.
Yeah.
There's no one to indemnify
We
you.
have to use Stampede that, that's separate from us, but, yeah.
And a lot of the producers that I see do buy policies that are based per event, so it makes it easier.
Mr. Miller, one way that we have found around that is what you already provide. If you do get in a situation like we've been in, and you don't trust the promoter or whoever's leasing your fairgrounds, we simply call Tulip, purchase it, and charge our customer for it, and then we're covered. And that takes them clear out of the loop.
Yeah, for a lot of the smaller, not super risky events, the TULIP program works really good. Because you know you're covered, you know you're automatically additional insured. Slide right through.
So to clarify that, then, to ask, say, a performer, you can say, we need your insurance paper and we need to provide us this event. Or provide insurance, special this event.
Yes.
Right.
Well, yeah.
You can ask them to do that?
You can ask them to do that. And if they say, well, no, we can't, our insurer won't provide it
Yeah,
on
I've
a
heard
per
that.
event
I've heard
basis.
that.
Well, okay, then we're not accepting of $1 million policy with a $2 million aggregate. We want a $2 million per occurrence, because we can be sued for 2.5. We want you to have a $2 million policy per occurrence policy with a $10 million aggregate. So that we know, we have a better comfort level that you haven't already used up your aggregate policy limits on some other claim.
And then list them, like on your little papers, list our fairgrounds can be listed right here. Because I've had them say, no, we can't do that, so it's the law to do that. So, yeah.
Well, the laws here in Utah are pretty specific. We're going to talk about that in just a minute. How do we know that the insurance is going to pay? Well, if the agreement requiring indemnification is signed prior to the loss, so they're agreeing to indemnify you. They've signed that agreement, that lease agreement that says they will indemnify you. Under the standard ISO general liability forms, it provides contractual liability. And that policy term says as long as the agreement's signed prior to the loss, we will agree to it. So you don't have to be named insured or additional insured on these policies that provide contractual liability, because you've already done it by way of getting them to sign the contract ahead of time. So if that's the fuss, is getting named, well, they're going to charge me $100 to name you as an additional insured. If you can confirm that they've got contractual liability, they don't need to name you additional insured. It's always great, it's good to do that, but it's not an absolute necessity, because you've already got what you're looking for. Their policy is going to respond to you. So you don't need to be a named insured. This was something that risk managers 10 years ago, they were telling all their clients, oh, you got to be named insured on everything. Get named insured on their policies. And insurance companies have figured it out that no, you know, they'll do it. The problem is now that you're named on that policy, if you have a problem with that vendor and you're going to outright sue them, their insurance policy is not going to respond because you're named on the insurance policy. One insured can't sue the other insured on the same policy. So you don't necessarily want to be named insured. You want to be additional insured, which just recognizes that your losses are going to be covered in some way, shape, or form by the policy as well. Okay, so don't get those confused. So a certificate of insurance is the way in the business to be able to show that this person has bought the policies that you've asked them to buy. It's really only, though, it's really just evidence that a policy was in place on the day that that certificate was issued. That's all it really proves for you. Beyond that, it doesn't do a lot. So you still have to kind of trust the person. Unless you're going to get a certificate every single day of the fair. And there's a few risk managers that I know that might do that. It's not a contract or an endorsement to the policy. So if they give you the certificate of insurance and they say, hey, all this stuff that you asked for in the contract, it's right there on the certificate, so it's all covered. Well, no. The certificate doesn't do anything. Again, it's just an indicator that a policy was issued. It has to be endorsed to the policy for it to be doing anything. It doesn't create any rights to the indemnity under the policy. And a lot of the certificates now actually say that right on the certificate. This doesn't create any rights to any policyholder that aren't already in our policy. And it's only good for the day it's issued. Because they could cancel the policy the next day. And I know a lot of risk managers over the years have tried to change the certificate form to say, if I'm a certificate holder and they cancel this policy, you're going to notify me, insurance company. Insurance companies aren't doing that anymore. Most of them say, we will notice you to the extent that we're obligated to under the policy. That's it. In the policy, I can tell you, the standard ISO forms do not create any obligation for them to notify a certificate. So is it worthwhile? Well, you know, like I say, a lot of risk managers are trying to toy with the way that the certificate is crafted and what it says and what it can do. And over time, it got to the point where here in Utah, the Utah Certificate of Insurance Act was passed about 3 years ago by a state legislator who just happened to also own an insurance agency and who currently is the Commissioner of Insurance. So he knew a little bit about insurance. He was frustrated with the way he saw certificates being used. People were trying to use them as a policy. So under the Utah Certificate of Insurance Act, there's a few things that you should understand. The form has to be approved by the Commissioner of Insurance. So each company, insurance company, gets their certificate form approved by the Commissioner. Once he's approved it, they cannot change it. That's their certificate form. They have to go back to him if they want to amend it and change it. So they can't change the certificate language for you. And they'll tell you that. And the Act creates penalties for people who don't comply with the Act, and asking for a change to the form is not in compliance. So you can be penalized for asking them to change their form. So don't push that form. It can't refer to contracts on the certificate form. So again, if you've got somebody that's providing you a service at the fair, you have a contract with them. In the old days, I told my clients, just refer to the contract number on the certificate. Quick and easy. Can't do that anymore. I'm not sure what the commissioner's gripe with that was, but you cannot refer to a contract on the certificate, other than the policy itself. You cannot show additional insured status on that form unless it's actually endorsed to the policy. So if they showed on the certificate that they named you additional insured, and then you have a loss and you go to the company and the company says, we don't know anything about this. We never endorsed you to the policy. Because I'll tell you the truth. Insurance companies don't issue certificates of insurance. Agencies issue certificates of insurance. And very, very often, more often than not, the agent does not tell the insurance company that they've issued a certificate. They're handing them out all day long. If that's the case, now their agent is penalized for having issued a certificate that showed you as an additional insured, but you weren't actually endorsed onto the policy. Well, that's great that he's getting a penalty, but their insurance company isn't indemnifying you because you were never named additional insured on the policy. So again, make sure that they know, that you know. When you ask them to do that, and it shows it on the certificate, let them know. Now, the policy's actually been endorsed, right? Because otherwise you're in violation of the statute. A certificate can't change policy terms. It can't create rights for the certificate holder. So again, a lot of people would ask, well, I want on there that it's going to specifically say that you're going to pay for certain things for me. It doesn't do anything when it's on the certificate. You need to get an endorsement from the company. And don't be afraid to ask for an endorsement from the company. Ask them for a copy of the endorsement, or ask them for a copy of the certified policy, a certified copy of that policy. Because again, you need to know whether or not it's covered. If they're using standard general liability forms, you know, I know what's in the standard general liability form. I don't know what it is if they're using some other form. So you might want to get an actual copy of their actual policy. And you can't just go around this by asking them for a letter or a memo of some sort to clarify that they've got the insurance. That's still going to be considered a certificate of insurance in the state of Utah, and it falls under the act.
So a lot of this certificate of insurance language can be put on your contract with them. You want to, when you're building your contract, you can put, must provide certificate of insurance and it must show that you are fully insured through the whole event.
Well, when you ask for that, and you're gonna set out what the minimum requirements for them, for their insurance is gonna be, then you're gonna state that they're going to provide you a certificate of insurance so many days prior to the event that shows that the insurance is in place during the event and for a specific time period after the event, that it names your additional insured, and that it names Uinta County additional insured and shows Uinta County as their certificate holder. That you can ask for, because those are fill-in-the-blank pieces of the certificate form. If you say, we want you to change the notice provision on the certificate to so that you must notify us within 10 days if the policy is canceled, that was the standard 10 years ago, you can't do that anymore. Whatever the certificate says as far as notice provisions to the certificate holder is it. And you have to live with it. Or pass by. And again, don't be afraid to pass them by. I got a call last year from the Juab County attorney. He had this vendor whose contract was just really outrageous. And he really didn't know if he wanted to move forward with this. And I reviewed it and I said, well, if they can't make these changes to it, I'd say, Cat, find another vendor. Which he did. They found another vendor. And a few months later, he called me and said, hey, did you see the front page today? It was the vendor that in Summit County lost all of the data on the ticket purchasing people. But we caught it in another county just because they spent a little more time. No offense, but they spent a little more time, looked at that, and they were willing to say, no, we're not comfortable with the provisions of your contract. We're going to find another vendor. At some point, you need to be ready to do that. So
I have a question.
Yes.
I actually have, I guess, an additional. We've worked with a vendor for probably 5 or 6 years, and now they're going to go to Davis County. I know you're into this. They send us our certificate. We look at it. It's got the amounts. It's got the year, everything on it. And you send it back and say they don't have this and this and this and this. Well, we just look for what we asked for. So how do we know? I mean,
I've got that as an example.
I knew you would, but I wanted to know how, and we can't pass because there's just really no other vendor that does what this gentleman does. So do we have to send all of our certificates of insurance to you? Is that what we should do now so that you can review them before they come to the fair? I'm just asking because we don't.
I'm going to show you a few things on the certificate that are red flags, that if you see, then they should come to the risk manager at the county, and they'll probably send them to review to make sure that the certificate is getting what you're asking for.
And see, most of our certificates come in the week or so of the fair. Our contracts that we have, that you are saying all of the information about insurance is in our contract. They said that they're good on it, and then they get a week before the fair, and then we get what we've got.
Right.
Then what do you do?
Well, again, in that situation, that's why, again, you need to make sure that in the agreements that their obligation to indemnify you is not limited by the amount of insurance that they purchased or you asked for.
So if they've signed that contract and their certificate's not good, are they liable?
Yes, they're liable to indemnify the county for any claim that's filed against the county resulting from their activities at the fair. So you're going to end up with a whole bunch of animals.
Yes, we are. And a great big huge tent. Okay, so, but as long as it's in our contract and they've signed it, we're somewhat covered on the county's part.
And Johnny, Jan, one of the things that you can do is something we do in our contracts is put in there that failure to provide a certificate or failure to actually secure the insurance does not release them from that liability, so that it's clear to them
I
that they
want to give
can't.
that clause because
Yeah, I
ours
think
just states that if they don't bring all the insurance that we're requiring. But what
There's
happens if they don't?
That's something that we added, and we actually make them initial that so that they understand that failure to do that doesn't release them from that obligation.
Perfect.
And again, having that conversation with them, you know, if you're cheating on the insurance, understand, we're still gonna, you still have to indemnify us. So are you willing to lose everything that you own?
Well, in our correspondence, you
Buy
basically said,
insurance.
the vendor probably doesn't even know. He's probably paying for something that he doesn't even receive.
He's-
So, yeah.
I wouldn't doubt that that vendor is sending premium to some guy in Maitland, Florida, who is putting it right here.
He's picking up the
It is
certificate.
going, it's not going to any insurer whatsoever. This is what it looks like to me. So don't ask for changes to the certificate form, don't ask to refer to a contract. And you don't need to be additional insured if you can see on the certificate or on the policy that they have contractual liability. When you receive a certificate from someone, the important things you're looking for is who is the insurer? Is it a company that you've heard of? Is it Dave's Insurance that you? If it's Travelers, if it's Chubb, if it's Hartford, those are all good things. But Dave's Insurance in Dubuque is not a good thing. Okay? And that's a really easy one. You just simply go on to Google and Google the insurance company, and it should give you a link to the AM Best site that will actually show you the ratings for that carrier and let you know whether or not they're a good carrier or not. Who is the insured? Again, watch out on the policy. I get this all the time, that you're contracting with Joe's Backhoe Incorporated. But it comes to you, and the certificate is written out for Backhoes Unlimited America. And it's like, well, what's that all about? Oh, well, I'm an additional insured on Backhoe America policy. Well, that's not your insurance. You don't get insurance by being additional insured. So make sure that the person, that the name on your contract is the name of the policyholder. Check for the dates on the policies and the policy numbers. One of the problems that I saw that we're going to look at, a certificate that's issued before the date that the policy is good for, and if you ask for certificates way out ahead of the fair, and their policy expires and renews on August 1st, and you ask for the certificate in July, well, that certificate in July should be for the policy that expires on August 1st. If they issue you one that starts on the next August 1st, it's an invalid certificate. Because the certificate itself says, this is evidence that a policy has been issued. A certificate is not for a policy in the future. It's only for the one that's in place. So check those dates. Check for all the coverages and limits that you asked for. Again, if it's a food vendor, you need to make sure that the certificate shows that they have products liability. General liability isn't going to pay for a claim for food poisoning. They need to have products liability endorsed onto that general liability form to cover that exposure. If it's a contractor who's building you something, they need completed operations coverage. So that when the building falls down because it wasn't engineered correctly, the policy will respond. That's just a standard general liability policy won't do that. When you have questions about what you should be asking for, again, contact your county's risk coordinator. That is my main contact, and I'll work back and forth with them or the county attorney to make sure that we've got what you need. Okay? And make sure that the county is shown as the certificate holder, and as if you're going to have additional insured, that they're the additional insured, because like Dale said, the county fair, well, the county fair really isn't an entity, but the argument will be if that caused a loss to the sheriff's department, the if they cause a loss to the sheriff, well, we didn't agree to indemnify the sheriff's department, we agreed to indemnify the county fair. We wanted to indemnify the entire county. Unless your fair board is a separate legal entity from the county, then you'd name the fair board and the county. Okay, but don't limit it by just saying the county fair, or the county event center, or whatever it is. Make it as broad as possible. And the biggest one, if you see any evidence of whiteout on a certificate form,
Not good.
do not accept. That's not the way they're done. So let's look at a quick example. This is the certificate, for those of you who haven't seen it. Again, it says it's issued as a matter of information only, confers no rights. It's telling you that a policy has been issued. Again, it's usually issued by the agent or broker who issued the policy. Some agents and brokers are authorized by companies to issue certificates, others are not. Some of them actually have to go to the carrier to get a certificate issued. More and more, I think carriers are going to require that they get issued by the carrier. But check the agent, where they're from. The insured's name, as I said, again, make sure it's the person that you're contracting with that owns the policy. It's going to then show information about the carriers that are providing the insurance. So you'll see it refers to insurer A. Well, that insurer, if that's Chubb, then they're providing the coverage under this box A. Insurer B, if that's Travelers, is providing the automobile liability under box B. That's how you read the form. So very seldom, if you're asking for liability, some specialized, special events type coverage, products liability, workers' compensation, automobile liability coverage, very seldom should you see that provided all by one carrier. There's very few carriers that package everything up like that. You probably see at least one carrier for the liability and auto and another one for the workers' compensation. So be watching for that. So you've got the general liability area here. Again, this one covers commercial general liability. Here's the one area that we talked about, how long you want them to have the policy maintained for. If the box claims made is checked, you want to make sure that they continue to maintain a policy for this amount with you being protected under it for at least a year after your event. Because as a government entity, you can be sued in the state courts for up to a year after the injury. A claims-made policy is going to pay claims that are made against you within the policy period. If the occurrence box is checked like it is on this form, then anything that happens during the policy period is covered by that policy. For your purposes, with your events, you prefer that those vendors have occurrence. Because then if that policy was in place during that time period and the aggregate wasn't used up, you're okay. If they are using claims made, and this again is something that we specify in the agreement, is that if they're using a claims made policy, that they must maintain that policy for at least a year, or maybe even 4 years if you're concerned about federal, a claim that would end up in federal court after the event. Okay? It's funny because claims made coverage is better for you as an insured, but when you're dealing with someone else, you want them to have the occurrence form. And oftentimes, the occurrence form will be cheaper, so you'll find that most of your insurers, your people that you're working with, they're all looking for the cheapest thing. So that's usually what you'll find. And here, you see that there's a box checked with contractual next to it. That's what you want. That means that they have contractual liability, so as long as they've signed the agreement to indemnify you prior to the loss, this policy is gonna respond. Okay? Automobile liability coverage, and again, you're gonna see the limits over here. You're gonna see the per occurrence limit, what that is. Any aggregate limit is gonna be shown there. Now, if the limits here, if you're asking Carnival for $5 million limits, you get this and it only shows $1 million here with a $2 million aggregate, you next then need to jump down to the section for excess or umbrella. If the excess or umbrella shows $4 million, now you've got 5, so you're okay. So make sure before you get them on the phone and you double check that. Automobile, they've got any auto is covered, that's great. And they've got their limit there. The excess coverage would be here. Workers' compensation is also on this form. Again, really important that you make sure that they have workers' compensation for all their employees so that they don't make the argument that they can sue you for their injuries or that they can, that they're actually your employees. Description of operations, we see all different sorts of things typed in there. And again, it's great if they describe that it's the Juab County Fair, August 5th through August 7th. Great, that's fine to have in there. If it's something that you're requiring of them, that be like contractual liability, that should be checked up here. That shouldn't be in the description down here. Okay. So if there's something odd in there that you're not sure of, get it to me, take a look at it and see what it is. Okay? Again, county here. That's the certificate holder. It's the best way to do it. If you want to do county including Sevier County Fair, Superior County Fair Board, something like that, okay, but make sure the county is there first and foremost. See the cancellation provisions, which then generally they're not going to be notified. We looked at all of that. So here's our example. A couple of things that we found on this form. This is one that was just sent to me this year for the upcoming fair. And you see that we've got a producer out of maintenance form. And you see the difference between that form and the one I just showed you. The one I was showing you was the ISO Accord form, the standard industry form. This one, kind of, but not really. I don't know why they wouldn't use an Accord form. Other than that, this insurance agent doesn't want to spend a couple $100 a year to participate in Accord. Would be the only reason. So that's my first question in my mind. Date of issue, 3/18/2015. Policy doesn't start till 3/28/2015. This is absolute garbage. This insurance agent doesn't know what he's doing. He can't issue a certificate. He's certifying that this policy is in place, but telling you that it's not. Big red flag. The named insured, Bunky Booger and Connie Booger. Doing business as Animal Specialties. Now, it's not Animal Specialties LLC, it's not Animal Specialties Inc., it's nothing. It's two people. I'm a little concerned that you're contracting with mom and dad and not a company of any sort. That's that kind of draws a red flag for me as far as them being, that's who's the insured. Got the standard language they stole from Accord here, but they warn you right here, limits of liability shown may have been reduced by any paid claims. They all say that right on it. So you're not going to have that argument of, hey, you didn't tell us that there was another claim. So we've got general liability claims made. So again, that's a problem. You may get sued after this policy is expired. It's a manuscript policy form. As soon as I saw manuscript policy form, I said, wait a minute. Who would write a manuscript policy form for general? Oh, this is, the company that's issuing this insurance is Lloyd's of London. Certain underwriters at Lloyd's of London. Now, there are a lot of names at the Lloyd's of London, but they are all actual insurance carriers. One of the names has to issue a policy. That's who should be there. It should be an insurance company. It should be Morpho or any one of the other names that are part of Lloyd's of London. It shouldn't just be underwriters at Lloyd's of London. Underwriters at Lloyd's of London don't insure. They underwrite. And they give that underwriting recommendation to a carrier who issues a policy. So they issued this policy, the policy number was kind of odd for me too. That didn't draw as much concern as other things. So they've got $1 million limit, $1 million per occurrence. Wait a minute, $300,000 E. coli per occurrence in aggregate. Let's see what that's about in just a second. The additional insureds are Legacy Event Center, Davis County Fair, and its officers, agents, and employees. Again, didn't make it quite as broad as we would like it. If the county is sued, because they rarely sue the event center or Davis County Fair. I don't very often see that on the suit papers. It's Davis County. We didn't name additional Davis County as the additional insured. So they named the event dates here, event location. Okay, so several things that just really bothered me about this. So, told the risk manager in this county, get a certified copy of this policy, because that's very strange. I have no idea. It says it's a manuscript form. I don't know what it covers or doesn't cover. So get a certified copy of the policy. So asked for that. They said, no, but what we'll give you, we're going to give you a new certificate that's dated now after the date that the policy went into place. And we're going to also give you this addendum to the policy, which then made me go back and take a look. The original one said that this certificate is no good unless it has addendum A attached to it. So the first one that they received wasn't any good anyway, because it didn't have addendum A attached to it. So then I start reading through addendum A. Okay, so there's all the same information. But as you start looking at the coverages that are provided in the exclusions, the owner's liability is afforded for traveling animals, a petting zoo, with domestic animals. So number one, no exotic animals. No reptiles, no nothing. Farmyard animals, that's it. While under the direct control and supervision of the named insured and or their employees only. So none of this, well, we need a couple of your volunteers to watch the ponies while our guys are, Bonnie and the voters are on break. Well, no, because as soon as they're not supervising the animals, there is no insurance. So you need to make sure that they or their employees are supervising the animals at all times, or you shut it down. Same thing with you can give the pony rides, but only under their supervision. They can have one large pig and one large horse under a big top. So again, as you started going through these, and here's the E. coli limitation, that's a pretty good exposure, pretty big exposure. Is they're letting kids pet the animals, but yet any infection by E. coli or any other bacteria, no matter how transmitted, there's only $300,000 of coverage. Is that adequate? You asked for $1 million, right? You're not getting $1 million. And they're not going to cover any direct damage to any other person's damaged property or anybody else's animals unless it's specifically endorsed to the policy. So could their animals injure somebody else's animals that are there at the fair? Like, are they stored together, things of that sort? So again, you really need to start looking at all of these things to determine whether or not they've got the coverage. Again, if you ask them for workers' comp, this specifically excludes workers' comp, and their certificate of insurance had nowhere on there that they were providing workers' compensation insurance. And they're going to have several employees, I would think, to keep the animals under their supervision at all times, right? So if they tell you, well, no, we're a mom and pop organization, it's just me and Connie, we're exempt from workers' compensation as sole owners of the business. Well, what about these other 3 people that you've got here watching the animals while you're on break? Well, they're just family. No, they gotta be employees and they gotta be covered by workers' comp. Okay? This is just if they ask you for a certificate, we won't worry about that. So make sure the proper party is indemnifying. Use solid indemnification language, again, by using your county attorney. Request certificates and keep them on file for at least a year, and 4 years is what I recommend. And review the requirements on the certificates and the bid specs. If you make sure that you're very clear in your bid specifications, if it's that type of a situation, or your call for, we're accepting proposals to be our entertainer at our fair, make all of this very clear in those agreements, because otherwise you choose the person you want, you're way down the road with contracts and stuff, and now they say, oh, well, we can't get them. Is $500,000 okay? And you're going to say, oh, well, I guess, we're 2 days from the fair, yeah, we'll have to accept that. So make sure they know far enough out in advance of what you're asking for. And when in doubt, again, contact your person in the county, that's the USIP coordinator, and we will assist with reviewing that indemnification language, the types of limits and insurance that you should require. It will help review and track the certificates of insurance and handle any claims if they do occur. Because again, they'll sue the county, we'll get the claim, we'll notify this other carrier, we'll ask you for their copy of the certificate they gave you so that we can contact the carrier and let them know that we're going to tender the claim over to them. And again, the workers' comp, that should be shown. And if they say that they're exempt, they can't be exempt if they have any employees. The exemption in workers' comp is if they're a sole owner, provider. If they have any extra people, they're not going to be exempt. They can still get proof of being exempt from the Department of Labor, so if that's their claim, get that from them. And if they show exempt status, they shouldn't be showing up with anybody to be helping them out. Okay. That's it.